1027 is the removal after petition filed. So they're both basically talking about the same thing, the removal of the child from its home. Adjournment in contemplation of dismissal. Be prepared to be stunned with stupidity. Family Court Act, Article 10, 1039, with explaining a little bit about the legislative intent. And then Dorothy will explain to you why this is so absurd. Article 10 was essentially drafted so that kids wouldn't just sit in foster care indefinitely. Keep that in mind. Subdivision A, prior to or upon a fact-finding hearing. So again, prior to or upon a fact-finding hearing, so not after. The court may, sua sponte or on motion of petitioner, whoever does the motion, everybody else has to consent. The court may order that proceeding be adjourned in contemplation of dismissal. Under no circumstances shall the court order any party to consent to an order under this section. The court may make such order only after it has apprised the respondent of the provisions of this section and is satisfied that the respondent understands the effect of such provisions. So the time limit is up to 1 year. Up to 1 year. That's what it says, right? A period not to exceed 1 year with a view to ultimate dismissal of the petition and furtherance of justice. Same as every other adjournment. Okay? Such order may include terms and conditions agreeable to the parties in the court, provided that they shall include a requirement that the child and the respondent be under the supervision of CPS during the period. The agency shall make a progress report no later than 90 days after the issuance of such order unless the court decides they don't need it. CPS shall make further reports to the court, the parties, and the child's attorney in such manner and at such times as the court may direct. D. Upon application of respondent, petitioner, or AFC, which is child's attorney, or sua sponte made at any time during the duration of the order, if the CPS has failed substantially to provide the respondent with adequate supervision or observe the terms and conditions of the order, what does the court do here? What do you think? The court may direct CPS to observe such terms and conditions and provide adequate supervision, or make any order authorized pursuant to 255 of this act. Okay. Upon application of the child's attorney, the petitioner, or sua sponte made at any time during the duration of the order, the court may restore the matter to the calendar if the court finds after a hearing that respondent failed substantially to comply, basically. In such event, unless the parties consent to a 1051 order, or unless the petition is dismissed upon consent of petitioner, the court shall thereupon proceed to a fact-finding hearing under this article no later than 60 days after such application, unless such period is no later than 60 days. The fact-finding shall commence no later than 60 days after the application, unless such period is extended for good cause shown. If the proceeding is not so restored, period is dismissed in the interest of justice, unless an application is pending pursuant to sub E, which is what I just read. If the application is granted, the petition shall not be dismissed and shall proceed in accordance with sub E. Notwithstanding the provisions of this section, the court may, at any time prior to dismissal of the petition, issue an order authorized pursuant to 1027. And 1027 is removal of the child. So now, let's go to 1051.
1051. Sustaining or dismissing petition. If facts sufficient to sustain the petition are established, or if all parties and the attorney for the child consent, the court shall enter an order finding that the child is an abused child or a neglected child and shall state the grounds for the finding.
Upon consent of the petitioner, respondent, and the child's attorney, the court may issue an order extending such time period and conditions as may be agreeable by the parties. It's because in ACOD you think it's going to be dismissed after 1 year. But no, You come in and they're like, no, you didn't live up to our standards. You got to do all this other stuff and you got to agree to it. Or I don't know, maybe something bad. You're maybe going to go to jail. I don't know what could happen, why anybody would agree to this, because they can extend it for any time period. It doesn't put a limit on it. It doesn't put a limit on it. But as everybody knows, in the other articles, there's no extensions on any of the other articles. Just this one, Article 3, Article 7, there is no extensions. Just Article 10. And thank you, Barbara, for letting us know, because now we will see it on the test and know.